However, they did argue that the jury charge was correct, as stated in the.
I guess just to clarify, did they make that argument during the trial, or I wasn't sure if you were referring to...
I don't believe so, but I believe that they did read that definition to the jury, if I remember correctly.
Counsel, do you want to reserve some of your time for about,
How much do I have?
how much time is left?
Okay.
4 minutes for rebuttal.
Okay, I'll reserve.
Okay, thank you.
Thanks.
May it please the court, Counselor. My name is David Vernon. I represent the state of Texas, people of Johnson County. Clearly, y'all are very well versed in the law. Judge Neal's opinion, my opinion. I can only imagine that you requested oral argument on this because of Justice Gray's dissent, or you have a period interest in necrophilia. I'm not sure which, I'm not saying. But I would, to Justice Neal's point,
Sir, could you speak up
it is
just
the
a little-
application paragraph.
Could you speak up a little bit, please? Could you speak up? I don't think opposing counsel can hear you.
Okay, well, I
Thank you.
couldn't hear her either.
Okay.
But I'm just old. The application paragraph is, in this analysis, is paramount. It is what authorizes the conviction. It's not the abstract definition.
Well, let me ask you this, though, counsel, to look at the other side of this. If the defendant did everything he could, he objected at the right time, and we say this is not some harm, what's the purpose of the abstract portion of the jury charge ever? I mean, does this mean that now trial courts are not going to have to get it right at all? They don't have to worry about the application, or they don't have to worry about the abstract portion, because as long as the application paragraph's right, then there's going to be a whole bunch of error. Isn't that going to lead to a bunch of error in the jury charge? It just gets overlooked.
I think it comes in play in the Almanza factors, because one of which is, what does the indictment say? Because it's read to the jury as well. If you have a conflict, and it would look like this, that on about this day, Johnson County, Texas, the appellant did then and there intentionally and knowingly cause death of an individual, namely Alexandria Wright. By intentionally and knowingly, and then going through the manner and means. If that's in the application paragraph, that's confusing. If it's not, then intentionally and knowingly directly modify the result of conduct. But what if the indictment doesn't? I've seen many of these where you get new attorneys go into intake and they just go hog wild with the culpable male states. This is not uncommon. So even though the application paragraph would control on that, it still causes confusion and it moves the needle towards some harm. Not a lot, but I mean, obviously if you get the application paragraph wrong, I'm not saying in and of itself that's going to show some actual harm, but it certainly is a major factor in that.
So you're just saying that the abstract portion is only a little bit screwed up, but if it's really screwed up, then you have some harm.
I think that's just something that you're going to have to look at in the overall picture of things.
You'd also look at the evidence and the argument of counsel, right? So the case law seems to be in your favor on this. But if, as to Judge Newell's question, if the state had argued that the contested issue was only whether he intended to choke her, and the jury got that idea from argument and what other evidence was at trial, is that something that would, in spite of the application paragraph curing the definition paragraph, could that cause harm?
I'm sorry, I probably need hearing aids. I
That
didn't
was
catch
probably
it.
me. Never mind.
Okay.
That's okay.
Well,
I'm not sure I can
the
repeat
point
it if I-
that Judge Keller, I think, was trying to ask you or get at is the idea that we also look at the arguments of counsel. And
Right.
in this case, we don't have a situation where counsel argued argued the abstract portion and said, all you have to find is that he intended to engage in the conduct, not that he intended to engage in the result. And if a prosecutor in some future case had done that, that would be something that would factor into whether or not there was some harm, despite the small amount of error in the abstract or in the abstract portion of the jury charge, because the prosecution is really leaning into it. That might rise to some harm, even if the jury charge itself is only a small error.
I mean, I keep going back to Almanza. I think Almanza was well written. It covers the gamut here, from indictment all the way to the last thing it says is anything relevant to this inquiry, including notes from the foreman of the jury, which Justice Gray had used.
So I'm sorry, could you speak up? I'm having a hard time hearing you.
It's because of the air conditioning.
I'm just saying that the factors that were set out in Almanza covers any scenario on this. So we would cover that situation as well. It would cover the indictment, it would cover the application paragraph, argument of counsel. Did counsel focus only on result of conduct, which in this case they did, but I can see if they didn't, they just gave lip service to it, that may not, I mean, that's not going to be the equal value as an application paragraph, but it is going to swing the needle one way or another, and that is a reviewing court's responsibility to look at all of this. And I mean, there's no exact formula here. We have to live with that, but you know, if the application paragraph did include a nature of conduct associated with the manner and means, as well as the elements, the indictment also had the same confusion. If the evidence tended to really focus on the choking, not the death, and the argument of counsel the same way, then easily you've missed the some harm or some actual harm standard.
What about the argument that defense counsel or appellant's counsel is making, that we should look at the use of the word intentionally sort of as a reference back to the definition portion, sort of in the same way we might do with the law of parties. The law of parties doesn't actually apply the definitions for party liability. They put that in the application or the abstract portion, and then they say you're found guilty of or as a party. And that reference to party liability then brings the entire definition of party liability, or the entire abstract portion of the party liability, into the application paragraph. And as I understand, appellant's argument is that's kind of what happened here, or the argument is that that's what appellant believes happened here, is that when they saw intentionally, they had to go back and look at this definition, and then they thought, well, intentional means I can just say intended the conduct, not just the result, even though the application paragraph goes on further and says you must show the result or intend the result.
Well, typically when you review this, you look at the rules of grammar and what is modified. Intentionally, knowingly, directly modifies the result. Yeah. It's not used at all in connection to the underlying conduct. At one point, we have to assume that the 12 members of the jury collectively have the intelligence to realize this is a murder case and you need a dead body. Ultimately, it's not an ag assault case. You know, so.
Do you know why? When I look at the jury charge, I noticed that the trial court limited the definitions of mental states with regard to knowingly and recklessly, but to result of conduct situations, but did not do so with regard to intentional. Did that was that ever become an issue in the trial court? I mean, did y'all talk about that, or
The trial attorney, and you know, he is board certified, so he's had many years of practice and lots of trials under his belt. He got off onto that and tried. He rationalized not limiting the definition of intentionally because of 1902b2. And there was a case in which he cited Ned versus State out of the 14th Court of Appeals. It was not a jury charge argument, but it was an indictment. And the defense said, well, you need both definitions in there. It's error to exclude nature of conduct definition of intentionally. And the 14th Court of Appeals says, well, it is in there, it's imputed. The you know, if you intended the result, naturally, you intended the underlying act. So he went with that, and that's why he felt both definitions needed to be in there, and that's why he argued strenuously for it.
Well, but I'm saying they were limited. They were limited in the way that the defense in this case argues that the definition of intentional should have been limited. But
Correct.
the definition of intentional, for some reason, did not limit itself to result of conduct applications of that definition. And that's what I was kind of curious about. But I'm also curious about why, if you know, the defendant was not also charged with 19.02b3 homicide, which would have made the defendant guilty if he merely choked the defendant and then she died.
I don't know, and I wouldn't have charged, if it were me, 1902b2. I would have just gone with the b1. So I don't know what their thinking was on that case.
Well, to build off of what Judge Erie is saying, in that situation, the nature of the conduct instruction might actually be correct because you're showing that this person intended to engage in conduct that could cause serious bodily injury, and then the death results. And then you are looking at whether or not he intended to engage in that conduct. But that's not in the application paragraph. I mean, that part isn't, right?
Right. Well, I'll make a note to talk to our intake and any questions about the attack on Almanza and changing it to theoretical error only as far as requiring reversal? Y'all didn't bite on that.
Sorry? We
Y'all
didn't bite on
bite
it.
on it. Okay.
I am curious about, because I also looked at Castile, and I'm not as familiar with civil jury charges as I am with criminal. I wondered, do you have any more experience with civil charges versus criminal charges to be able to enlighten us about the answer to the question that Judge Newell asked?
I'm a criminal law lifer.
Okay.
I avoid civil like the plague, so. All I looked at was the incredible burden it was going to put on trial judges in the state to get this right if we were going to reverse just based on, if your creativity of thinking of a possible harm. Well, I think the jury was thinking this without testing the likelihood of that.
I'm also curious about this. This court has said that it is error to fail to restrict a definition provided for in a statute to the whether it's a result of conduct or circumstances and so forth. Is that something that is only the fact that whether or not that's error, is that only guided by opinions from this court, or is there some statute that that says that trial courts should strike out parts of laws that they think might not apply to a case when they're giving the jury information about what the law says generally? That's a long question. I know it might be hard to follow, but I'm asking generally, aside from this court's cases saying that it's error to give the jury information about a complete definition that was provided for by the legislature without trial court interlineations, that's error. Is there some statute that says trial courts shall not do that?
Top of my head, I don't know. I just know that, under...
Well, how broad is the phrase law applicable to the case?
I'm sorry, what?
How broad is the phrase law applicable to the case? I mean, that's really the question. There's a statute that says you should instruct on the law applicable to the case. Does that mean that says that the judge can't then instruct on something that's not applicable to the case?
That I don't know. I know the judge has the obligation to instruct on the law applicable to the case, but can he sua sponte just say, no, y'all are wrong, I'm going to strike
Well,
this?
I mean, does that statutory provision prevent the trial judge from instructing on nature of the conduct, say in this case, in the abstract portion of the charge?
I would think the judge could, if he asks the trial attorney and trial attorney argues, no, this needs to be in there because of this case and that case, I think the judge is free to say, I disagree. I don't think that's the law applicable to the case.
More importantly, are we here to determine whether or not there was error, or we determine what degree of harm there is?
The degree of harm, I had fallen into that trap as well, because this is a confusing area of law.
Sure.
And there is no TDCA guideline that, makes it, couple mill states for dummies. And we are forced to go and look at the case law when we have a particular offense, whether it's taking copper from a compression station and you're having to go under natural resource code to find it, which we've done. I harp on the attorneys, at least get research into it. We may not get it right, and, it'd be nice if there was a guidance for us so we wouldn't make a mistake. And for that reason, I think the judge should exercise his authority and say, no, I don't think so. And then we live with it on appeal or die on appeal on it. Anyway, I don't have anything else unless,
Thank you, counsel.
okay, thank you very much.
I don't have a lot more to add either. I do think that as attorneys, whether we're defense attorneys or the state, the prosecutors, judges, trial judges, justices, we have a duty to get things right. I like to see the justices done, and as I mentioned before, in this case, there's really no way to show that there wasn't any harm, and there's no way that show that there was harm. We don't know what the jury looked at, so we want to make sure that we give we don't give the state or the court, by putting in something like a wrong definition like this, to take the ability of the jury away, the ability for the jury to decide guilt or innocence, because that's why we have jury trials. So what we're doing is we're taking away the defendant's right to have the jury decide whether he's guilty or innocent, because we're saying you have to look at this definition, you have to look at it intentional as either or kind of thing. Okay, so I believe that's harm right there.
Let me just ask you two questions.
Sure.
He testified, did he concede that he choked her?
Yes.
When he testified? And is it your position that the way the jury charge was written, that it did not provide him an avenue of getting a lesser included? Once he admitted he choked her.
That's exactly.
Were lesser includeds in the jury charge?
They were. There was manslaughter and a criminally negligent homicide. But even if they were to look at those, then you come back up and you see, okay, but we've already got murder.
There was no way to get there.
There was no way to get to them.
Did anyone request that the jury be instructed about whether the crimes that were charged were result of conduct or nature of conduct offenses?
I do not believe so. There was just an objection to that as an incorrect
But technically,
definition.
the definition was an exact replication of what the legislature wrote. Isn't that correct?
For the jury charge?
In the jury charge, the definition of intentional was an exact replication of what is found in our statutory law.
Yes, but for murder, for a result of conduct case, where the result has to be intended, it should be tailored. And it was tailored for knowingly, but it wasn't tailored for intentionally, and I'm not really sure why not either.
Right. Is there a statute that requires that it be tailored?
I believe it's in case law. I think that what the problem with one of the other problems with this particular saying, well, this doesn't cause any harm, is now other cases with the same facts, you can put that same definition in there. I'm not saying courts would, but they could. And if they did, again.
Well, counsel, I don't mean to cut off your
Sure.
airtime here, but the fact that they're putting these definitions here doesn't necessarily mean that people are going to say, well, that's fine, Because we're still going to say that it's error. We're assuming that it's error.
Right.
We're just determining whether in this case, in this specific case,
Right.
it resulted in any harm.
Well, I think it does result in harm because you're not allowing the jury to assess the whole thing. They're going to have to do murder. And in addition, it will harm if it's you set a precedent, it would harm in other cases as well. Okay. Any other questions? Thank you. I appreciate you taking the time to listen.
Thank you, counsel.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.